Take us through, fans have asked a number of times, well, he wasn't convicted of any crime. How can the NFL suspend him? Take us through the steps and just the difference between the hearing that Sue L. Robinson wrapped up and is getting the briefs on and any type of criminal thing that would have been brought against Watson.
Sure. Well, thanks for inviting me on. I don't know how the connection is in this room, but if we're having a problem, you'll let me know. So the NFL has always made clear in its personal conduct policy that they're free to take on their own investigation, irrespective of whether a player has been charged with a criminal offense, irrespective of how things play out in either the criminal or civil justice system. The NFL will have its own investigative process and make their own determination as to whether the player committed violations of the personal conduct policy, which covers a wide range of activity, ordinarily centering on, crimes of violence, sexual assault, a wide range of misconduct, but domestic violence, sexual misconduct, that area is tending to, come up, in some of the more recent cases. And the burden of proof is going to be different in the NFL's investigative process. Now, they don't have the subpoena power to force witnesses to cooperate, but the level of proof is going to be much lower than it is in a criminal trial where all the jury has to find by proof beyond a reasonable doubt that the accused committed the crime. In a civil lawsuit, the standard of proof is a preponderance of the evidence, meaning it's more likely than not that the offense occurred. Traditionally, under the NFL's personal conduct policy, they used an even lower standard called credible evidence, which is basically any evidence that could be credited by the NFL that would tend to support a finding that there was a violation, even if it's outweighed by other evidence. And today we're learning, and I wrote a lengthy piece for my website, Conduct Detrimental, and I said, hey, it's not fair if the NFL uses a credible evidence standard, because courts have found that to be unconstitutional in a trial proceeding, because it would allow the finder of fact to disregard other evidence and just basically cherry pick one or two strands of evidence, and the weight of the evidence could support the player. So several courts have found that to be a violation of the due process clause of the federal constitution. So today the NFL has, announced, or through reporting has conceded, that they're going to apply the same standard of proof that is used in civil lawsuits. Now, this won't play out in a court. Under the new collective bargaining agreement, there's a disciplinary officer, former retired federal court judge Sue Henderson, who was jointly selected by the Players Association, by the National Football League. Under the old CBA, the NFL meted out the discipline, and then all appeals were taken to Commissioner Roger Goodell. So what's new about this current system is that we have a neutral fact finder in the phase one level. Goodell still hears the appeal, but the NFL and the Players Association agreed on a jointly selected hearing officer that can make the initial determination as to whether the player committed the violation, and if so, what the punishment should be.
Yeah, and that is, as you mentioned, retired Judge Sue L. Robinson.